Marijuana. Not this calendar year, but the previous calendar year, as I'm sure you all know, the Minnesota Legislature approved recreational cannabis for homeowners. The statute, if you're bored, is Minnesota Statute 342. Originally, it was supposed to go into effect, some provisions on July 1st, 2023. There was also some provisions that were supposed to go into effect on March 1st of 2025. As I'll talk about in a minute, that March 1st, 2025 effective date actually got changed this year, so it's now already effective. As it relates to you guys in the HOA world, generally speaking, the law says that smoking or vaping cannabis in multifamily housing is against the law. That provision was supposed to go into effect March 1 of 25. That actually went into effect July of 24. So it is technically against the law to smoke or vape in multifamily housing. If you want to eat a marijuana gummy, a cookie, one of the drinks that you see everywhere, that's not against the law. That said, just because it's against the law doesn't mean you can call the police and say, I smell my neighbor smoking, and the police are going to do something about it. They might, but if I was a betting man, I would bet that the police are going to say, yeah, I don't care. I have other things to deal with. The other piece of this, however, is that it is a nuisance under the statute to smoke or vape marijuana in Minnesota. And I'll talk about what that means in practice. Yeah, so the July 1st, 2024 is the new deadline. I do want to touch briefly on growing. Growing marijuana under the new statute, as a general rule, is allowed. If it's inside your home, you're allowed to do it. If it's outside your home, and this is true anywhere, not just in HOAs, if it's outside your home, there's a couple of things you need to do. It has to be not visible from a public right-of-way. It has to be in some sort of locked container that's inaccessible to people. So I can't just have a giant marijuana garden growing in my front yard. I have to have some sort of like greenhouse structure. As this relates to HOAs, and I'll just keep this part brief, if you want to outlaw growing of marijuana on the interior of your HOA community, like in someone's home, you would need to amend your governing documents to do that. There's no way to do that without. Whether or not you need to do that, probably not. It's going to depend on you. The one thing to keep in mind is that when marijuana plants are flowering, they have a very pungent smell, even if you're not smoking it. The actual growing of it makes a very, very distinct, strong odor. So you could have someone who is growing marijuana in their unit, and it may stink up the whole hallway or the whole neighborhood. That's legal, and unless you put something in your declaration, you probably can't stop them. So this is the actual provision. And so the question was, for anyone who didn't hear, how does the state define multifamily? Unfortunately, it doesn't. And I'll get to that, but I want to walk through this provision a little bit. It says, except for medical cannabis and medical cannabinoid products, the vaping or smoking in multifamily housing, including balconies and patios, is not allowed. So everything I've said goes out the window if someone's got a medical need for marijuana. And I treat this, and I think everyone should treat this as you would any other accommodation for an exception to the rule under the various discrimination statutes. Very quickly and briefly, the relevant state and federal statutes are the Fair Housing Act, that's the federal one, and the Minnesota Human Rights Act, that's the state statute. Both of them say largely the same thing, but they say if your HOA has a rule or a policy or something in the governing documents that you can't do, and you need an exemption for medical reasons because you're handicapped or disabled, you have to allow that. So the common example would be, I am in a no-dog building and I need a dog for my anxiety or because I'm blind. You have to allow the dog. So sad, too bad that it's a no-dog building. It doesn't matter. That right of that homeowner because of their handicap or disability overrides the association's rules. And when I look at this particular issue, honestly, any issue for an HOA, I look at it from a practical perspective. I can put my nerd lawyer glasses on and get real wonky into the weeds, but let's solve a problem, right? Let's figure out the best way to move forward. We're going to talk to both of them. We're going to talk to the board. We're going to talk to whomever we need to and say, let's find a solution that makes everyone equally unhappy but acceptable, rather than fight the fight and push both sides. With any sort of reasonable accommodation under either the MHRA or FHA, the association has the right to ask, usually, for very specific limited amounts of information. You can't ask for 20 years of medical records. And I won't go too far down the rabbit hole here, but what the association can generally request is a note from some sort of medical provider, usually. There are other people that could qualify that aren't medical, that says the person is handicapped or disabled, and those are legal definitions, under the definitions, and they need the accommodation. You don't get to know what the handicap is. You don't get to know what the disability is. You don't get to question it and say, I don't think you're really blind, or I don't think your anxiety is that bad. If you've got the requisite paperwork, you make the accommodation. I've helped maybe a dozen or two associations navigate those complaints when they happen. You don't want to do that. You don't want to have to pay me to actually go through and navigate that, because you're fighting the government, right? You're either fighting the federal government or the state government. It costs money, it takes time, and all of the agencies and entities that help enforce these are going to be very, very handicapped or disabled person favorable. Unless they say, I am handicapped because I only have one arm, and you have a picture of them with two arms, short of something that stark, they're almost always going to defer to, give them the reasonable accommodation. That's a pretty broad thing. So if they don't provide the documentation, then the answer can be, you haven't provided any documentation, therefore we're not granting you this accommodation because we can't confirm you need it. They can get paperwork from, there's a very broad spectrum of people that you can get that paperwork from. This is one of those situations where if the association isn't going to say, we'll give this accommodation, I would say contact your attorney, because it's going to be so fact specific, and frankly, there's a lot of risk here, because if you get caught up in a discrimination complaint, you're going to get dragged into a battle for months and months at best. It can be years. So you want to avoid that if you can. Having an attorney help you navigate that and say, this is what you can do, this is what you can't do, this is what you can ask, this is what you can't ask, is the best way to approach it. I do want to talk to the original question that was asked back here. I'll come to you in 1 second. About how you define multifamily housing. The statute doesn't specifically define it, but it does say multifamily housing buildings. So the building itself means the structure. And it also includes balconies and patios appurtenant thereto. So you cannot, as a matter of law, smoke in your units currently on the balconies or patios. That said, the green space outside of your balconies and patios, maybe you can, maybe you can't, from that perspective of the law. We'll talk about the nuisance stuff in a second. Many HOAs, the board is given the authority to regulate the exterior, the yards, the common space, and in that case, the board could adopt a rule that says no one can smoke on the common areas, or you can only smoke in the common areas in this corner here, by the dumpsters, what have you. The law, whether or not, the police and the courts could enforce it's illegal to smoke is one thing. Police, in practice, aren't going to get involved in you smell pot on your patio. That said, the statute does specifically define the smell of marijuana, assuming it bothers you, which it sounds like it does, as a nuisance as a matter of law. And that, because it's a nuisance, it is likely a violation of your declaration, because most association declarations contain a provision that says you are allowed, or you have the right to quiet enjoyment of your property and to not experience as nuisances. So because the statute says it's a nuisance as a matter of law, I think, and I advise boards, when you get a complaint, to send out a reminder or a letter or some sort of communication saying, we've taken action. We understand Mary Lou, or the owner of Unit 6 or the owner of a unit has explained that she doesn't like the smell of marijuana. She smoked it here, here, or she smelled it here and here. The association's board, in my opinion, should send out some sort of communication. If you know which unit it came from, okay, send it to that unit. And maybe your board has already done this, I don't know. Because very likely, if the board sent something like this out, there's no way you would know that, right? Because the board's actions like that aren't necessarily public. So the board, in my opinion, should be sending something out saying, hey, dear new homeowners, or generally people who live in this area, just a reminder, it is a nuisance to smoke marijuana if it bothers people. We've got evidence that it bothers people. Please stop. I, in addition to being practical when I advise associations, am also very risk averse and conservative. I am going to tell you the thing that is most likely to protect your association. I think very clearly what I'll call true condo building, so common entrance, hallways, apartment style, that's going to be considered multifamily housing. Townhomes, where they are sort of attached, let's say 6 side-by-side row homes, maybe, maybe not. I err on the side of, listen, let's assume that's multifamily housing. Let's address marijuana smoking the way we would and assume that it is a nuisance as a matter of law. Single-family home associations where you've got an HOA, but everyone has their own home that is not connected anywhere else. Probably not multifamily housing, but also it's probably a non-issue because if I'm in my single-family home HOA, out in Plymouth and I'm smoking a joint, how is my neighbor going to smell that, right? Like it's not connected, there's no common airways, that sort of thing. If smoking is allowed in your association, okay, smoking's allowed. I don't care if you think it's hurting your lungs. You moved into a unit in a building in a community that allows smoking, sorry. That's a losing battle every time.